Question number 101. Who is the officer in charge of the reserve police line under the UP police regulations? In reserve police line, the reserve inspector will be the in charge. Correct answer is option C. Question number 102. Under which provision of CRPC a court may convert summon case into a warrant case? Correct answer is section 259 of CRPC. Question number 104. To what facts of the following the rules of relevancy has been discussed under section 8 of Indian Evidence Act? Options are motive, preparation, previous or subsequent conduct, all of the above. Correct answer is option D, that is all of the above. Question number 105. In the case of kidnapping and rape, the evidence given by prosecution being illiterate and rustic young women, some contradictions and omissions are natural as her recollection, memory, observance and narration of chain of events. It has been held by the Supreme Court in 2011 in the case of options are Manoj Yadav versus Pushpa, State of UP versus Chote Lal, Madhu Verma versus Urmila Devi, and D. Lakhan Lal versus State of Bihar. Correct answer is State of UP versus Chote Lal. Question number 106. A person suffering from any mental disorder can be exempted from criminal liability ipso facto, cannot be exempted at all, can be exempted from such liability at the discretion of the court, can be exempted from such liability on proof by expert evidence to this effect. This is the right answer. Therefore, option D will be the question number 107. Evidence obtained by undesirable means is admissible if it is otherwise relevant. The court said so in Pushpa Devi M. Jett versus M.L. Vadhva, Harprasad versus Shivdayal, Kalpanath Rai versus State of Maharashtra, Raun versus State of Maharashtra. Correct answer is Pushpa Devi M. Jett versus M.L. Vadhva. Question number 108. Assertion. The testimony of elative and interested witness may be relied upon by the court. Mere relationship does not by itself discredit the testimony of witness. This is also correct. Therefore, the option A, that is both A and R are correct, and R is the correct explanation of A is correct. Answer with the help of code. Handwriting may be proved. Evidence of the writer himself, opinion of expert, evidence of the person acquainted with handwriting, the code under section 73 of Evidence Act. Here all the options, that is evidence of the writer himself, opinion of the expert, and evidence of the persons acquainted with handwriting and the code under section 73 of Act, all the given options with related to handwriting may be proved. Therefore, all the options are correct. Question number 110. The facts showing the existence of any state of mind under section 14 of Indian Evidence Act relates to intention, knowledge, good faith, all of these. Correct answer is option D, that is all of these. Question number 111. Photocopies of a document made from the original are primary evidence, secondary evidence, hearsay evidence. None of the above is correct. Correct answer is secondary evidence. Question number 112. Which one of the following case related to dying declaration? Options are Mehboob Shah versus King Emperor, Queen versus Abdullah, Kotaya versus King Emperor, MC Varghese versus Ponnek. Correct answer is Queen versus Abdullah. Queen versus Abdullah is a leading case related to dying declaration. Question number 113. Which of the following section relates to secondary evidence? Options are section 60, section 80, section 63, section 62. Secondary evidence is related to section 63. Question number 114. Relevancy of expert evidence for the purpose of Evidence Act is contained in section 10 to 20, section 35 to 40, section 45 to 48, section 59 to 60. Correct answer is section 45 to 48. Question number 115. Under which section of the Evidence Act provisions for presumption as to gazettes in electronic forms has been made? Correct answer is section 81A. Question number 116. A kills B. A is charged for murder. In this case, the burden of proof is on the state. Correct answer is state. Question number 117. Contents of electronic records are proved in accordance with the provision of section 65, section 64A of Evidence Act, section 67A of Evidence Act, section 65B of Evidence Act. Correct answer is section 55B of Evidence Act. Question number 118. Which of the following statement is wrong? If a person forcibly resists the endeavor to arrest him, the police officer may use all the means necessary to effect the arrest, cause the death of such person irrespective of the offence he has committed, cause the death of such person accused of murder, cause the death of such persons accused of culpable homicide not amounting to murder. Here the correct answer is option B, that is cause the death of such persons irrespective of the offence he has committed. This will be the wrong statement and other options are correct. Question number 119. Under which provisions of the Code of Criminal Procedure a court at any stage of trial may recall and re-examine any person already examined? Correct answer is section 311. Question number 120. Under which section of Code of Criminal Procedure 1973 the term offence has been defined? Correct answer is section 2N. Question number 121. Bailable offence means an offence which is shown as bailable in the first schedule of CRPC. Question number 122. Under the Code of Criminal Procedure 1973, the classification of compoundable and non-compoundable offences as provided in section 320 of CRPC. The classification of compoundable and non-compoundable has been provided. Question number 123. Which of the following is not correctly matched? Information cognizable cases section 154 CRPC, arrest by magistrate section 44 CRPC, content of charge section 211 of CRPC, trial more than one offence section 218 of CRPC. This is not correctly matched, therefore this will be the correct answer. Question number 124. The Supreme Court has issued guidelines while effecting the arrest of a subordinate judicial officer in the following case. Correct answer is Delhi Judicial Service Association versus State of Gujarat. Question number 125. Under section 29 of the CRPC, second class magistrate can pass sentence up to 1 year.